Good afternoon. So we would like to look at one question within the context of legal system. And the question is this: discuss customary law as a source of Ghanaian law. And then there's a follow-up question. In terms of the internal conflict of law rules under Section 54 of the Courts Act 1993, what will be the personal law of Atta, an offspring of a matrilineal Fante father and a patrilineal Ewe mother? So let me see if I share the screen for you. Well, as we have told you before, this is the type of exams you have to pay attention to almost everything, including the most elementary of the topics. If I say the most elementary, that is the basics, which we may have like the strong temptation to often overlook or not pay significant attention. And you go to the exams room, you have maybe a question which looks so simple, but because you haven't included it in revision, you will not be able to produce a good answer. Yeah, so one of such basic topics is what we have in the question that I extracted from some of the old part questions. I just weave some together. So discuss customary law as a source of Ghanaian law. And then we have like a short follow-up question. In terms of the internal conflict rules under Section 54 of the Courts Act 1993 at 459, what will be the personal law of Atta, an offspring of a matrilineal Fante father and a patrilineal Ewe mother? Good. So, as pretty straightforward, if you'll be paying attention to your Ghana legal system, we will first discuss customary law as a source of law. Now, to start with, you remember that when we look at Article 11 of the Constitution, the point was made that under the sources of law in Ghana, we have one big source known as the common law of Ghana. Now, the common law of Ghana, as we have noted, include the rules of law known as the common law, and then the doctrines of equity, as well as customary law. So this afternoon, we are talking about customary law. That is what you're interested in this afternoon. We're not talking about all the three at the same time. So customary law, the point we have to be made, is a component of what is known as the common law of Ghana. And you notice that customary law, according to the Constitution, Article 11, are rules of law which by custom are applicable to particular communities in Ghana. So the rules based on custom, but not just custom in general, custom which are applicable to particular communities in Ghana. So therefore, if you are asserting something as a customary law and it cannot be linked to a particular community in Ghana, that will not be a customary law. So let us keep that in mind. And if you talk about customary law, as you appreciate by now, it transcends so many things in society. Acquisition of land. So when it comes to land law, we have a whole area of customary land law. You know the various interests in land held at customary law, the allodia, the supervisory interests, the tenancies, abunu ebusa, and so on. So all these are manifestations of customary law. And the same thing also applies to marriage. When it comes to marriage too, customary law is there. Then what used to be known as like the customary offenses. But now, because of the Article 19, customary offenses are no longer a part of us because every offense must be reduced into writing with the punishment prescribed therein. Maybe the only context in which customary offenses may be relevant is probably when it comes to aspect of chieftaincy. But apart from that, it's not really important now. Good. So these are examples of manifestations of customary law. Now, the other point to remember has to do with what we called the ascertainment or the status, or let me put it that way, the status of customary law. Now, we have to remember that prior to attainment of independence, during the colonial era, going back to the Supreme Court Ordinance of 1876, the legal position used to be asserted that any allegation regarding existence of a customary law was a question of fact, not a question of law. And that principle was also articulated by the Privy Council in the well-known case of Angu versus Atta. Angu versus Atta. Then the point was made that questions regarding customary law are questions of fact, unless it has been proven many times over and over again that it is so notorious that the court need not go into inquiry to establish its existence and so on. So that was a very major way of classifying customary law. Now, the implication for that, I mean, in saying that customary law is a question of fact, was this, that when there's a dispute before the court and one of the parties allege that it is against our custom or it is against our customary law for you to do this or for you not to do that. Now, under the Angu and Atta regime, that is, the customary law is a question of facts and not a question of law. What that meant was that the person who was asserting that something was a customary law had the burden of proof to adduce evidence to convince the court that, as a matter of fact, the alleged customary law really existed. Now, let's compare that with what other situations of the law are. For example, if you assert the common law, right? You say that the postal rule is that as soon as the letter is properly addressed and posted in the usual way, acceptance is deemed to have taken place. Now, that is a proposition of law that you have asserted. And this proposition of law is an aspect of the received English common law. Now, when you make such an assertion, even if your opponent disagrees and say that that is not the law, you do not bear any evidential burden to adduce evidence to convince the court as whether the proposition of law that you have asserted is really true or not. It is rather the duty of the judge, who is said to have the law in his or her bosom, to undertake his own research in order to verify the validity or otherwise of the assertion that you made. So that was the difference. Of course, one will argue that when colonial era, customary law was treated as a question of facts. Probably the point to be made that, well, if you look at our customary law, it's not written and so on and so forth. And you have non-Ghanaians who were operating the legal system at the time. So you don't expect that they'll be able to know the customary law, and that probably provides some justification. On the other hand, some people also look at it as a disrespect to our own culture and civilization, because, I mean, the common law, the received common law, is also a form of like a custom. The only difference is that it's documented. So if that is treated and respected as law, why don't you treat and respect our own as law? I mean, that is just by the way. But a good point to remember is that when we had our independence, we had the Republican Constitution and the various Courts Acts, we put in an explicit provision that henceforth, any question regarding customary law is not a question of fact. It is a question of law. It is a question of law. And as you remember from from your law of evidence that during trial, anything relating to law is to be determined by the judge. Then it's only matters pertaining to facts. If it's a jury trial, that will have to be determined by like, the jury. So therefore, if our Courts Act states that questions regarding customary law is a question of law and no longer a question of facts, what that implies is that anytime a position of customary law is asserted and there is a dispute as to its veracity, it is the duty of the judge rather than the duty of the party asserting it to actually establish its existence. So let us keep that in mind. And that is why, Martin, I'm teaching online. I'll call you when I finish. Okay. Yeah, and that is why in the interesting case of University College of Cape Coast, right, against Anthony, there was a high-class society wedding, and the Catholic Athens Standard at the time arranged, and a picture was taken of a lady, and subsequently, at the University College of Cape Coast had it made into a postcard, and I think they wrote at the back of it, Asian hairdo or something like that. The lady who was in the picture felt offended and decided to sue, claiming, among other things, that the picture was some sort of like an innuendo. That people who know her and so on and so forth will be able to associate her with the picture, and then it will put her in a very negative light, that she is a cheap lady, and then she, despite the fact of being married, she engages in a cheap act, so as to earn a living by advertisement and all that, when she had not consented. And she also argued that it was an invasion of her privacy rights. Now, that case had an element of customary law, and she asserted Fante customary law, that in Fante custom, if such a picture and so on, the way that was published, creates the impression that it was done with like the consent of the woman. What that meant was that being a married woman, it will let her appear in a very negative light, and society will look down upon her and so on. Now, when this was asserted, the judge, that is the Justice Redu J, as he then was before he rose through the ranks, he did not actually conduct his own inquiry, his own research regarding the truth or otherwise of such a position in Fante customary law. So he went ahead and did his own and came to his conclusions and all that. So when the matter came on appeal before the Court of Appeal, the Court of Appeal, of course, reversed the decision of the High Court, and they're holding two, which is relevant for our purpose, is what I've quoted here, and then let me quote it for you. Customary law was not now a question of fact, but one of the law for the judge. If the judge was not himself affaired with any rule or content of it, Section 50 of the Courts Act 1971, Act 372, enjoined what he should do to ascertain it. He should, if he were unsure of the customary law, have consulted the reported cases, textbooks, and other sources as might be appropriate. Failing that, Act 372, Section 50, subsection 3, obliged him to hold an inquiry in a prescribed manner to instruct himself of the content or rule of customary law. Since the trial judge failed to hold an inquiry in the manner prescribed by the law, the opinion evidence of the witnesses who gave varying versions of the custom about the publication of a married woman's photograph was inadmissible, unquote. So, just to illustrate the point being made that customary law is not a question of fact, it's a question of law. Now, interestingly, the Courts Act 372 has been reenacted as what we know at 459 in 1993. So if you look at the Courts Act 1993 at 459, Part 3, it said that common law and customary law. And there are two provisions there, which every student should be familiar with. If you are interested in answering any question on customary law, assuming you were lucky to get a question on customary law. That is the Section 54 and also Section 55. I will jump Section 54 and I'll come back to it. Let's go to Section 55. Section 55 is headed Ascertainment of Customary Law. So it actually prescribes the steps which a judge should embark upon in order to ascertain whether customary law exists or does not exist. And that is why 55(1) makes the point that any question as to existence or content of a rule of customary law is a question of law for the court and not a question of fact. So this reverses the principle in Nangu versus Atta as we have noted. And again, just as we saw in the case of University of Cape Coast above, if there is doubt as to the existence or content of a rule of customary law relevant in any proceedings before a court, the court may adjourn the proceedings to enable an inquiry to be made under subsection 3. After the court has considered submissions made by on behalf of the parties, and after the court has considered reported cases, textbooks, and other sources that may be appropriate to the proceedings, just as the court alluded to in the case that we saw, the UCC case. Yeah, so the court will have to do its own library research. Are there textbooks, maybe like Saba Fante Customary Law, Olenu Customary Law, Olenu Principles of Customary Land Law, SKB Asante, Asante Customary Land Law, JB Dankwa, Buzia, Josiah, Aye, Woodman, Kwame Jan, and all the various writers on customary law. You have to consult those textbooks to find out whether you get assistance from any of those textbooks. And of course, if we have like a decided cases, then part of your work is accomplished for you. So you have to look at the law report as the case may be. But if it happens that you do not get any assistance from the textbooks, from the law reports, then you have to go to the next step, which is under Section 55(3). The next step is to actually hold an inquiry. And what is that inquiry? The inquiry is supposed to be held as part of the proceedings. So if you like, it would have to go like a mini trial of Wadi, so to speak. So the judge will have to allow people who know about the alleged customary law to come and testify in the witness box, so that at the end of all the testimonies, the court will be able to make its own findings as to what the true content of the alleged customary law is. So in terms of who will be heard during the inquiry, who will be allowed to give a testimony regarding the content of the customary law, the court will decide itself. Now, if you look at section 55, subsection 5, it directs that in holding the inquiry, the court may make a request to a House of Chiefs or the divisional or traditional council, as the case may be, that have knowledge of the customary law in question, to state its opinion, which may be laid before the inquiry in a written form. So the judge can actually formulate questions and send it to the traditional council in the area, or the divisional or the House of Chiefs, regional or whatever in the area, and require the traditional body to answer those questions, which will enable the court to arrive at some decision regarding the content of the alleged customary law. Good. So let's keep these steps in mind. If you are discussing customary law, you must always include discussion of section 55 of the Courts Act, as it were. So let's keep that in mind. And so that will help you to do justice to the first question that I put over there, that discusses customary law as a source of Ghanaian law. But if we look at the year 2015, there was just a multiple choice, but of course, you solve the multiple choice questions now, but just the aspect which relates to the sources of law. So I thought we should look at it. And this is how the question ran. Quote, in terms of the internal conflict rules under section 54 of the Court Act 1993 at 459, what will be the personal law of Ata, an offspring of a matrilineal Fante father and a patrilineal Ewe mother? Then these were provided as the options. A, Fante customary law; B, Ewe customary law; C, the common law of Ghana; and then D, any of the above by which the justice of the case warrants. Okay, we are not interested in this any of these options, but we're interested in understanding the personal law. Once we know what the personal law is, we can right away answer this question and any other similar questions. So we need to consult section 54 to be able to answer that question. And section 54 addresses what we call the choice of law, okay? And or what we call like the internal conflict of law rules, as it were. So let's keep that in mind. So if we look at section 54 of the Courts Act, it has a provision to the effect that subject to, of course, this Courts Act and any other law, a court, when determining the law applicable to an issue arising out of any transaction or situation, shall be guided by the following rules, in which references to the personal law of a person are references to the system of customary law to which he is subject, or to the common law, where he is not subject to any system of customary law. Good. So personal law, as a general rule, refers to your customary law. Now, where you don't belong to any customary law community in Ghana, then the common law will apply. So let us keep that in mind. Now we have some rules of thumb which have been provided to help the court to determine what the appropriate law is. So rule 1 under section 54, An issue arising out of a transaction shall be determined according to the system of law intended by the parties to the transaction, to govern the issue or system of law, which the parties may, from the nature or form of the transaction, be taken to have intended to govern the issue. So it is the transaction in question which will first of all determine whether the parties will like the so it is the nature of the transaction which will help the court to determine the particular system of law applicable to it. And if we look at the rule 2, in the absence of any intention to the contrary, that is, the parties have not indicated any intention, as we can distill from the nature of the transaction with reference to rule 1, then the applicable law to any issue arising out of the evolution of a person's estate shall be a personal law of that land, of that person. Of course, the law of succession and equity is not part of your examinable areas as a standalone model, but because Ghana legal system is still part, that is why you should still look at this particular rules that we are talking about. Otherwise, when it comes to succession bit, if the person died intestate, for example, if you look at the PNDC law 111, we have a solution as to what the position of the law should be. And this will not present any difficulty at all. Rule 3, in the absence of any intention to the contrary, the law applicable to an issue as to title between persons who trace their claims from one person or group of persons or from different persons, all having the same personal law, shall be the personal law of that person or those persons. Yeah, so this will, for example, become relevant when we are dealing with like some aspect of land law, especially customary land law. And you have 2 or more people who are claiming title to a particular thing, and they all have one person as a grantor. Then the position of the law is that it is the personal law of the parties which will be applicable since they all have like the same personal law. And then Rule 4 under Section 54 of the Post Act also state that in applying the 2 rules, that is Rule 2 and 3 that we've looked at, relating to titles to land, due regard shall be had to any overriding provisions of the law of the place in which the land is situated. If you do no conflict of laws or private international law as a course on its own, there's what we call like the less situs, right? That is the less loci. The place, the law of the place where the subject matter of the dispute is located shall actually hold sway over any other law in some of the conflict of law system. Then Rule 5 under Section 54, subject to, that is all that we've looked at, Rules 1 to 4, the law applicable to any issue arising between 2 or more persons shall, where they are subject to the same personal law, be that law. And where they are not subject to the same personal law, and this is where the question we look at in the beginning becomes relevant. And where they are not subject to the same personal law, the court shall apply the relevant rules of their different system of personal law to achieve a result that conforms with natural justice, equity, and good conscience. So let's say that we have a transaction between 2 parties, right? One is from matrilineal customary law system, and one is from a patrilineal customary law system. Now, certainly, these 2 systems are pointing towards divergent directions, looking in opposite directions. And you cannot just say that we are going to use a matrilineal system or we are going to use a patrilineal system. Just like the example that we saw, let me show you like the the question again. Just like the question that we had here. With respect to Ata, who is an offspring of matrilineal Fante father and then patrilineal Ewe mother. Depending upon what is at stake. Of course, if it is depending on what is at stake, since the two are pointing towards different directions, that is where Rule 5 of the Section 54 become important. That the court will have to apply aspects of both different systems in order to achieve justice. So therefore, of course, we are not doing MCQ. If we're doing MCQ, one would say that the answer will be D, because any of the above by which justice of the case a warrant, and that is consistent with Rule 5. It's consistent with Rule 5 under Section 54. Because if you ask, we quoted that where they are not subject to the same personal law. So in this case, they don't belong to the same customary law system. One belongs to patrilineal, the other belongs to the matrilineal. Then the court shall apply the relevant rules of the different system of personal law to achieve a result that conforms with natural justice, equity, and good conscience. So let us keep that in mind. And the same thing also applies with modification to Rule 6, that in determining an issue to which the preceding rules do not apply, the court shall apply such principles of the common law or customary law or both as would do substantial justice between the parties, having regard to to equity and good conscience. So as you will notice, the rules are graduated. Where the preceding rule does not apply, then the lawmaker provide another solution, and that is what we are seeing in each of these rules, as it were. And Rule 7 also provides that the courts in trying to determine an issue arising from common law, customary law, are supposed to develop various remedies, especially so where the Supreme Court does not determine the relevant aspect of the law, as it were. I mean, 2 is about this is a saving provision of the rules of private international law or conflict of law, which were enforced before the coming into force of the Courts Act 1993. Yeah, so these are things that we should pay attention to with respect to customary law as a source of law in Ghana. So if there is any question on this, I will take it before I will end, and then I will come back. Maybe later this evening, we discuss criminal law in relation to murder and manslaughter. Any question on what we've done? If you want to speak, just put up your hand, and I will release you. Okay, let me release you. But just one person should speak at a time. Okay, so no question is coming. So we come back for criminal law later. All right. Have a good afternoon.